don't remember what level of formality we use for introductions for deliberations, so I'll just indicate that today we are scheduled for a public deliberation in Pikesville Hospitality Investors, LLC. It's CBA 21017. This is an appeal of permits, approvals, and inspections, PAI, and Department of Planning, DOP, director's letters approving the limited exemption development plan, LEDP, for a Royal Farm Store, gas station, and car wash, and which incorporates the zoning approval of a drive-in cluster planned. So previously, we held a deliberation to consider various motions filed by multiple parties. We then issued an order of remand to the director of PAI and the ALJ to evaluate whether the proposed development meets the criteria for a planned drive-in cluster type W. We then received a letter of April 29, 2022 from ALJ Paul Mayhew indicating that he had consulted with his colleague ALJ Murphy and Director Gutwald, and he was writing to express their collective view that, one, it was not appropriate for their office to give what they say would be an advisory opinion. Two, stating their view that this board's prior decision in Lessee involved this board reaching a similar issue on the merits, performing its appellate function, assuming that the DOP director did in fact have authority, further holding that the director's decision was an error, and saying it was dicta regarding, quote, future determinations under this current definitional language should at a minimum be ratified by the administrative law judge or director of PAI to remove any uncertainty regarding the validity of the designation to a particular development, end quote. I'm continuing to read from ALJ Mayhew's letter. He further states their collective view that Section 101.1 of the BCZR vests the DOP with the sole authority to determine whether or not a development meets the definition of a drive-in cluster planned. They further believe that the DOP's approval or denial is then a final decision which must be appealed directly to this Board of Appeals for de novo review. And finally, they believe this Board of Appeals has the sole authority and responsibility for conducting the review. Subsequent to ALJ Mayhew's letter, People's Counsel Peter Max Zimmerman sent a letter to the board indicating that his office would no longer pursue its appeal, which the Board of Appeals then treated as a withdrawal of that appeal. Mr. Nelson had filed a separate appeal, and so that appeal remains. So it's my understanding that this brings us, meaning this board, back today to decide the next step in this case. So with me are my colleagues Fred Lauer and Brian Pennington, who served previously and deliberated in the decision that resulted in the remand. So as I see it, let me further set up a bit here. We had a hearing on cross motions by the various parties. Venable, on behalf of its client, had moved for partial dismissal, essentially stating that all but one exception of the decisions had already been long ago determined and not eligible for appeal because the time had run. Mr. Nelson, on behalf of his client, had opposed that and filed his own motion for summary judgment, and largely what he argued is what resulted in our attempt to remand. And then Office of People's Counsel had filed its motion seeking various things that are no longer before us because he's withdrawn his office's appeal. So what I see before us to determine is whether to ask Ms. Cannington, Ms. Zahner, to set this case in for a merits hearing for a future date to resolve the various issues on appeal, or if there is a ruling on the outstanding motions that would dispose of the case in its entirety, that would eliminate the need for any merits hearing, or a hybrid of the two. If Venable's motion is granted in part, and because it, well, actually in full, I mean, it asks for partial dismissal, which would leave only a portion of the case to be scheduled for the merits hearing. My particular view and thoughts, we wrestled with this, or at least I did. I think we all had similar views the last time. My issues continue to be sympathetic to both parties. Venable is arguing three things in its motion. That both, number one, both appeals are untimely because they were filed beyond, when I say both appeals, I mean by Office of People's Counsel and by Mr. Nelson. They're untimely because they were filed greater than 30 days. Two, that the first appeal, which is People's Counsel, had no authority for People's Counsel to participate. And three, the second appeal, which is Mr. Nelson's, cannot challenge a legislative act as illegal special law. So certainly with Mr. Zimmerman withdrawing its appeal, that eliminates two in its entirety and part of one. Mr. Rosenblatt had argued that all but the limited exemption for development plan was untimely. So in other words, that he's conceding that the appeal from that final decision is timely, but that the prior three determinations are not. And so that Mr. Nelson cannot contest those prior decisions. Mr. Nelson challenges the timeliness argument, and we don't have much of a record. This would be a de novo appeal, but I wrestle with the competing arguments of, on the one hand, there was not public notice, and there's not notice of a decision to appeal. How can one timely appeal it? That largely had factored into my agreement in remanding. And then I'm sympathetic to the developer's argument that undue delay or delay is expensive, and where a developer follows proper procedures, that they should not be forced to incur additional delay and expense. But I think the issue is, the heart of it is whether the procedures were proper. We have the ALJ weighing in here and making it clear that together with the director, they're not going to hear it. So I think that we need to have a hearing on the merits. I'm not prepared personally, subject to this deliberation and hearing what the two of you had to say, to make a determination that any appeal at this point is untimely and is barred. I think, based on the way this case has made it to us, that we should reserve on any determination that one or more decisions has been untimely appealed, since Venable concedes that at a minimum, that final decision is before us. So I don't take this lightly, and I don't intend to cause anyone to incur additional expense or time unnecessarily, but I think the public interest here requires a full hearing. That's my initial views, and I'd like to hear from the two of you.
If I might, Mr. Chairman,
Yes, sir.
I think it probably is best if we do as you say, because if we're wrong about granting that partial motion to dismiss, I think it puts us back here maybe 3 or 4 years from now, which could really cause problems. I mean, I'm very sympathetic with the partial motion to dismiss related to the Department of Planning approval 4 years ago. And I do think there is undue delay, and a business, a developer, an individual citizen needs to feel comfortable that once they have the final approval, they can move on. They're vested, if you will, or they're set, and they can move on with their plans and their expenses, et cetera, et cetera. But I do think approach as you've suggested kind of makes sense to me. Just knowing that it may end up back here anyway, if in fact we're wrong about which I would tend to feel that this partial motion to dismiss, I saw a lot of merit in that. But I do think that, since we're going to have a hearing on the other part of it, we might as well deal with both issues at the same time. That's kind of my practical, from my appellate experience, thoughts about this and how we should proceed. Thank you.
Yeah, thank you, Mr. Lauer.
Makes
Mr.
sense.
Pennington, let's hear from you.
Okay, good morning, everyone.
Morning.
I mean, it makes sense what you're saying. The thing I'm iffy about is what more are we going to get at a brand new hearing that we don't already have regarding the motions to dismiss and the 3 earlier letters being appealable or not. I don't know what more we would get if we had a full new de novo hearing. I can see having the full hearing. Let's just say we agreed for the motion and granted the motion for partial dismissal. Then we have the whole de novo hearing on the granting of the LEDP. If we just put everything together and have the one hearing, we'll have obviously the de novo hearing for the LEDP, plus we'll have to rule on this motion. I don't know what more argument we can receive as far as the motions. So I don't know. I'm wrestling with it right now. I mean, I almost feel like we should roll on the motion. But are we prepared to do that?
Well, that's the issue you raised. So are you prepared to do that?
I think I am. I mean, I went through all these Meadows, the Fox brand case, Beth Tiflo, everything that's happened so far in this. To me, it seems like the DRC approval in September of 2018, that's an appealable event. I really think it is. The planned driving cluster approval, that's an appealable event. The DRP approval from 11/2020, which I do believe that was a public. Aren't those the DRP? They're public meetings with notice, and I believe I remember reading there was some dialogue with the community members when that was approved. So if that was approved in 2020 and there was no appeal taken, the only appeal was when the LEDP was approved. So I'm just going back to I understand the argument where they're stacking, okay, you're appealing the LEDP. Does that also mean you can appeal the granting of the planned driving cluster back in 2018? I don't think so. I think it should have been appealed when it was ruled on, when the letter was issued by the director. And to me, the developer, based on everything I've read and everything I've reviewed, the developer followed the proper procedures And if the procedures are not what the community or people's council deems appropriate, then maybe they should be changed. But they are the procedures as they are. So that's where I am on this.
Okay, so you're voting to grant Venable's motion for partial summary judgment on the 3 earlier approvals, leaving only
The LEDP approval.
the LEDP. Okay, so
That's where I am.
Mr. Lauer and I had indicated I'm inclined to defer ruling on that. Mr. Lauer seemed to echo that, but that's without the benefit of hearing from you. So, Mr. Lauer, does your opinion change?
Yeah, I agree with Mr. Pennington. I'm convinced. I've felt all along that the motion to dismiss had merits, and I'm sorry, but I agree that maybe we should just, I'm persuaded that waiting on it may not produce anything else, as Mr. Pennington suggested.
Okay, well, that's why we have public deliberations. We don't come here with predetermined outcomes, and obviously we haven't discussed these outside of this deliberation, so we don't know what each of us is inclined to do. And that's why we deliberate. We don't just pontificate. So as it stands, irrespective of what I now say, if you two now stand on where you are, that means we will be granting Venables for the developer's motion for partial dismissal, finding as untimely the appeal of the PRC, PDIC, DRP, leaving the scheduling of a hearing, de novo hearing on the merits for the limited exemption development plan, the LEDP. Am I stating that accurately? Is that where we are? That's what
Sorry.
you.
As far as I'm concerned, yes, sir.
Okay. Well, I'm persuaded by Mr. Pennington's comments, and so we'll make that unanimous. And I will ask Ms. Zahner to tell to herself or with Ms. Cannington to take the necessary steps to schedule that de novo merits hearing, and we'll consult with her about procedurally the written opinion and order memorializing this opinion and anything else that's necessary to schedule the remaining de novo hearing. Is there anything else that either of you want to say to correct what I've said, or just that you want to be heard on?
Nothing
I
else.
don't.
Okay. Ms. Donner, is there anything else we need to do before we end for the day or for this matter?
No, that should be it.
Okay, great. Well, then thank you, gentlemen. I appreciate your time today.
Thank you,
Thank
sir.
All right, have a good day.
Take care.